Alex here with part 81 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to direct my viewers to part 0 if you haven't seen it yet. That's the video with the detailed disclaimers and the underlying purpose of the channel. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We now move on to an ex parte motion. I think this is the first or the second. Most likely this is the first time that I've filed an ex parte motion. I can't recall now because there's a chance that I filed one several years earlier into the case and it was probably just denied offhand. But anyway, this is the first time that I have filed one after doing some research, that's for sure, because from my brief glance of the motion that I filed, it looks like I looked into how temporary restraining orders work, and this is very different from a order of protection against domestic violence, even though people mix those two words up. Temporary restraining order, at least in Nevada, has a different meaning, and it's used in ordinary cases, not necessarily domestic cases. Anyway, I think I also cited two what's the word? There's a words, irreparable harm. That's the phrase. I think I cited two irreparable harm in the motion. I haven't looked at it in detail because I don't like to do that. I like to kind of go into it and give you guys my reaction as to what I did at the time. But I did do a quick glance and I can recall a little bit as to my mindset at the time. I wish I could remember the details, but the gist of this dispute is that my son was having excruciating pain associated with his tonsils, and that we were getting him a tonsillectomy. And what I can remember is that we went back and forth on the appointments. And my frustration was that she insisted on setting the appointment. And now I can remember a little bit more. So just when I thought that the issue with denial of access to medical care was over, I can recall after the third motion that the court ordered that I was to be given a certain, I think it was 14 days notice in advance before my ex would, hold any of these appointments. And at that point in time, I thought that this dispute was over, but it wasn't. And now I just kind of remembered what she started to do. So she took that order and she weaponized that again. And the way she weaponized that order was she basically thought of it like this. Fine, I have to give you 2 weeks notice when I set an appointment, but I am the one that gets to set all of the appointments. And she took that to another extreme, which was that she can also postpone the appointments. And I wish I could remember the specific details, and hopefully it comes out in the motion that we're about to go through. But my recollection, at least now, is that there were a few times. Okay, so first I remember she wouldn't set the appointment, and then I recall either offering that I was going to set it myself, or that at the last minute she set the appointment. And then I recall her moving the appointment at least once, maybe twice. And I recall my reaction at that point being, no, you can't move this appointment. He's in pain. His daycare providers are telling me he's in pain. It's embarrassing for him to be in pain all the time when all the kids are happy. And she wanted to postpone it indefinitely. So she didn't say something like, hey, I need to move this a week. She said, I need to cancel this, without offering another date. Or maybe she offered another date, but it was a month or two later. And I opposed her on that, and she said she didn't care, and she threatened to cancel the appointment. At which point I filed a temporary restraining order arguing that our son would suffer irreparable harm. If I didn't argue that, then eventually at some point I do argue that. I learn about it. And it might not even be in my own case. It might be something that I don't know, help somebody else out with. Hey, I tried to file an ex parte and it didn't work. Make sure you talk about this one thing. I don't know. I wish I could remember these things clearly, but I think half of the fun of these videos is for me to go through the documents and actually remember stuff as I'm reading it. So anyway, I think at this point we can actually go ahead and take a look at what I have filed. Here we have my ex parte motion for temporary restraining order. Now, I mentioned that this was not what people expected. A lot of people use the phrase restraining order and they think that that's talking about domestic issues, domestic violence specifically. But they actually have a different name. They're formally referred to as orders of protection here. And I think other states have different names for them as well. Having known or having learned what the temporary restraining order is, I actually can understand now why that phrase came about. I imagine that before the states, all 50 states, enacted these protective order statutes, that this was probably how attorneys in the old days went about keeping one person away from the other when there was a domestic issue. This is kind of a bread and butter piece of a larger process. What this is mainly about is what they call preliminary injunctions in court. And you can get a preliminary injunction before the case is concluded when you can point out to the court, hey, I can't really recover the damage that I'm suffering or that I am about to suffer with just money. Like, money damages are not enough. And so I need this court to give me a preliminary injunction to stop this conduct now while we sort out who is in the right and who is in the wrong of whatever particular issues before the court. So the preliminary injunction is really the thing that is kind of the point behind the temporary restraining order. The temporary restraining order is a part that comes prior to the court considering a preliminary injunction. So when somebody needs the court to intervene, they typically need the court to do so immediately, and they need to do so before warning the other person. The main reason typically is that if the other person is warned as to what you're trying to block them from doing, they can go ahead and do whatever it is that you're trying to block them from doing prior to the court entering an order. And if the court hasn't entered an order, they cannot be held in contempt of court. So what typically happens is first somebody asks for a temporary restraining order, and that is you asking the court, usually ex parte. I'm not sure why else they would use this process at all. Ex parte meaning that your opponent isn't being notified as to what you are requesting. It's basically you secretly asking the court to do something without telling them. Anyway, you are telling the court, I need a temporary restraining order now, and these are the reasons why. And then the court will either grant or deny it. And then if the court does give you a temporary restraining order, there's typically like a local rule or a statute or something along those lines that forces the court to set a hearing on the preliminary injunction, usually within a week or two. So this is sort of part of the process leading to you getting the court to stop your opponent from doing something that's going to be harmful. Anyway, I can imagine now why people call orders of protection against domestic violence restraining orders, because my sort of thought here is that maybe before these other orders of protection were invented, maybe this was the way that it had to be done in the old days. And as I mentioned, the restraining order is bread and butter. It's a basic legal nut and bolt of the law. It doesn't really connect to any specific type of law. You can use it in any type of case as long as that general idea fits into play, which is I need you to not let my opponent do a certain thing because it's going to cause me more harm than I can recover from with just money damages. And I guess that goes a little bit into irreparable harm. So now that everyone kind of has a tiny bit, at least this is my understanding as to how these work. Now that people have more of an understanding, I guess we can go into this. But yes, what I'm generally trying to do here is I'm trying to get the court to order my ex to not cancel that appointment. It's all this work just for such a simple thing. And I think towards the end of the video, I might talk about maybe another approach I could have taken. So here in the first paragraph, I introduce myself as the petitioner. I am appearing in proper person, which means I'm indicating to the court that I'm representing myself, and I am filing this ex parte motion for temporary restraining order. As I mentioned earlier, ex parte relief is relief that you're requesting without your ex's knowledge and or without your ex's input. Let's go into points and authorities. Here's the factual background. First assertion is that, and I think this is just a summary, that both myself and my ex share a common child of age 5, and we are the natural parents of this child. Next assertion is that the court on May 27th, 2009 awarded us physical and legal custody jointly. Next assertion is that between the months of November 2012 and January, what I probably meant to say here is January 2013. Anyway, our son had experienced occasional flare-ups in his tonsils due to an infection that gave him discomfort. We took him to the doctor, and the doctor prescribed him antibiotics. His condition worsened to the point where the occasional flare-ups became several weeks-long inflammation. Next assertion here is that we met with another doctor. This is an expert, one of those eye, nose, throat experts who recommended that he have his tonsils removed. My ex stated that she would schedule the surgery date. His condition evolved into several months-long inflammation. I remember this, where he suffered significant but tolerable discomfort and minor pain, unless his upper throat area was touched, in which case he would suffer momentary severe pain. I sent an email to my ex regarding his tonsillectomy. Let's take a look here at the timeline. March 23rd, I sent an email. So this is about a month later. So we met the expert on February 27th, and about a month later, I sent her an email regarding the tonsillectomy. She failed to reply. Then on April 13th, okay, I'm already starting to get pissed off. So he's in pain, and weeks, months are going on, and she's not doing anything. Anyway, it's starting to tick me off. So I sent an email to her on March 23rd, no response. I sent an email to her on April 13th, and once again, no response. So let's see here. February of 27th, we met the expert. And mind you, by the time we met the expert, this was already a pretty big issue, because prior to meeting the expert, we were already talking to the doctors. So on February 27th, we meet the expert, and she gets an email March 23rd, nothing. She gets an email April 13th, nothing. And then on April 25th, he is indicating severe discomfort and significant pain and lack of his usual energy. I remember he was starting to get lethargic. You know what's pissing me off more? It's not even just that my ex isn't responding, but it's that I remember how the court responded to this motion. It's almost as though I'm more angry at the judge than I am against her. I feel like when it comes to my ex, she doesn't know any better. Her mental health issues are so severe that she really doesn't know any better. And that's mainly why our son needed to be protected. But who does know better is the court. The court knows better. And I'm not going to talk about it too much right now, because we are going to get into his court order. And that's probably where I'm going to spend a lot more time on picking apart what he's doing and why his reaction to this problem is infuriating. But we'll move on. We got here the April 25th, which was the severe discomfort. On April 26th, I called the expert, and yeah, this is starting to come back to mind. So I scheduled the appointment. And this was after my ex failed to respond after 2 months. I scheduled the appointment, and I advised my ex of the date. My ex finally responded after I set the appointment, and she requested that I cancel the appointment because it was unnecessary. Okay, so then she went ahead, she said that she would schedule a tonsillectomy, and I canceled the appointment and scheduled it for May 8th, advising her that she could push it back to a comfortable date. She expressed disapproval with the operation being done at St. Mary's and wanted to cancel it entirely so she could set it herself when she felt like it. We're going to go into these emails in a moment. I refused to cancel the appointment. I don't know how many concessions I can offer. It's just really about trying to trigger litigation. That's my honest opinion. She could react in a way that satisfies what I am requesting, which is, by the way, in the best interest of our child. But she knows that if she does that, she won't trigger more conflict. So she has to respond in a way that's going to make me file something in court that's going to perpetuate the conflict. And that is unfortunately consistent with our child continuing to suffer. Argument. So I'm citing here the law WDCR 43 subsection 1A and B, that I gave notice to my ex via email and personal service. However, because of the rule requiring her 24 hours to oppose, I would invoke subsection 2A. Anyway, I'm trying to use the legal rules to allow me to prevent my ex from canceling the tonsillectomy. And then I am citing another rule and then mentioning that it's been satisfied because our son is suffering and will continue to suffer extreme and immediate pain if his tonsillectomy appointment is canceled indefinitely. Nevada Supreme Court has established precedent regarding temporary restraining orders in family custody cases with circumstances varying. Judge doesn't care about any of this. Hearing for preliminary injunction, not yet necessary. My ex is agreeing that the tonsillectomy is appropriate. I am willing to allow her to briefly delay the surgery. And this is just me basically stating that I'm being reasonable, or as reasonable as I possibly can, and she doesn't care. Conclusion. I am experiencing a constant inflammation, or our son is experiencing constant inflammation in his tonsils. It makes it difficult for him to sleep and occasionally coughs, wheezes, etc., etc. Um, the only thing that I think I could have done better is to get an affidavit from the doctor indicating that he was going to suffer irreparable harm. But I honestly don't think I would have needed that. I think any other judge would have granted this or would have intervened. For whatever reason, my judge does not, and it's actually disappointing. But we can move on and pick apart what he's done when we actually get to that order that he's going to file in this case. Declaration, which is swearing under penalty of perjury that all of the facts that I have asserted in this motion are true. Certificate of NRCP 5 service, which is me citing Rule 5, indicating that I have personally served this particular document upon my ex's attorney. So I didn't even have to serve it upon her. I suppose it's still consistent with the rules, though, because what I'm basically saying is I need relief now. I don't have time to wait for you to respond. Here's a list of exhibits. So we got 1, 2, 3, 4 emails. We will go through each of these. Exhibit 1. So let's see here. Talking about child support not being paid, wondering if she wants to get him into a recreational activity. Coral Academy sent information regarding his kindergarten year, and wondering if there are any updates on his surgery. So this was the email sent about a month after meeting with the expert. Exhibit 2. This is me saying, hey, I'm really worried about his tonsils again. Is there a reason that you want to delay, or do you want to cancel? And this is me trying to work around and guess what it is that she's opposing here. And she has, it kind of makes sense that she doesn't want to reveal that she doesn't think it's necessary, because a few responses later, she responds after I've already set the appointment that she doesn't think it's necessary. So it makes sense to me in her sort of way of approaching communication that she's being strategic here, and that she's not responding to something because she's worried that then I'm going to be able to take action sooner. So one of the things that she would do is delay, and this is consistent with what she's doing. We got Exhibit 3, and now, okay, so this is a thread. So this is going backwards. So I'm going to go ahead and start from mine, which is, well, where do we start this? Hold on a second, guys. Where are we starting this? Okay, down here. So she's indicating, or I'm indicating, hey, I haven't heard back from you. He's in pain, so I scheduled an emergency appointment. And then she responds, and I'm not going to read through all these details. You guys can, of course, go ahead and do that. And if you have any questions, post them down in the comments below. But I'm going to glaze over this response. She's saying that he's not in pain. So she's basically controverting my assertion. And she's saying that I don't need an appointment with him. All she has to do is schedule the surgery, which she hasn't done for months. So she's telling me to cancel the appointment. The meeting with the doctor is not necessary. The insurance won't pay for it, etc., etc. So this must be something that please let me know when you have canceled the appointment. Don't threaten with court, blah, blah, blah. So then I said, you've been legally threatened because you've been sent repeated emails asking your opinion, what's going on, etc., and you haven't responded. I mean, I'm kind of paraphrasing here. That being said, if you don't have the card, send the information. So we're talking about the cards again. Army's tonsils. So I canceled the appointment for tomorrow based on what you stated, and I don't see anything here about the surgery, so that must come later. Maybe that's this email here. She's saying to cancel the surgery date, so then I must have set the surgery date. So at some point I scheduled the surgery, and then she's telling me to cancel the surgery. She says that she wants to reschedule the surgery early next week. Cancel the hospital date. She'll reschedule it. Okay, and then this is just, I'm not going to read through these every single word, guys. It's just too much. And then I'm stating here, the cards don't matter, that I've been asking for the past 2 months. What? So it looks like a dispute about the location. She has a problem with the surgery. This is what I talked about earlier with St. Mary's. So anyway, an email thread about getting him his surgery that's taking over the course of 3 months. And then here's her saying that if I don't cancel it, she will. So then this is when I respond with my motion seeking a restraining order. Okay. Next exhibit here. is me telling her attorney. On a separate note, I scheduled the tonsillectomy and she's scheduled to threaten to cancel it. And then I'm citing the 2 court rules here that require me to notify her either by email or fax, if I remember correctly. Okay, next document. And here's a request for submission. So rather than wait, which is something I talk about in the video computation of time, rather than wait, because this is ex parte, I'm submitting it to the court immediately. And that's just me indicating that this is submitted to the court, just the motion. There's no opposition or reply. And here we have the Rule 5 service again. Going into the aftermath, I have filed a, let's see here, an ex parte motion and request for submission. That's odd that I didn't include the motion opposition notice with that. Usually, I have to include that and determine whether or not I have to pay a filing fee when I file something like that. Makes me wonder if I filed it later on as a sort of standalone document or not. Anyway, I didn't have to pay any filing fees, so that's $0 in costs. My ex didn't file any of these documents, so she incurred $0 in costs. I didn't have an attorney at this time, so I incurred $0 in attorney fees. And my ex's attorney would have probably spent 15 minutes in reviewing all of this, including the emails. I'm not even sure she cared to call my ex. Something like this, the attorney probably knew that with this particular judge, it wasn't going to go anywhere. So 15 minutes at the rate of $250 an hour comes to $62.50 in attorney fees for my ex, as with my previous videos. If you'd like to post any questions, go ahead and do so down in the comments below, or you can send me an email at admin@theproperperson.com.